Hi, everybody. Thank you again for coming to my YouTube channel. Today, I'm going to talk to you about domestic support obligations. What does that mean? How does it affect your case? And what you need to look out for. So, let's just start off with this. This graph here, this is actually straight from my bankruptcy law textbook. So, for the paralegals and the legal study students who've been to chapter 7, you would recognize this already. I'm a big believer in graphs, even if you're self representing yourself, you're pro se. I think it's important to sometimes draw out this information. It just makes it easier to understand. And if you look at this, if you can understand what I've written here, then you got this. You already know what a domestic support obligation. You could look at the bankruptcy code, make your head spin. The definitions there, I don't even understand what they're talking about if I read the bankruptcy code. I had to learn bankruptcy through another way because the code is a great way to not understand what they're talking about. Okay, so keep that in mind. So, what are we talking about with domestic support obligations? Simply enough, we're just talking about alimony and child support. That's all it is. It's nothing more. And this is the very important part. I want you to understand that it's not dischargeable in bankruptcy. So, if you're I get this a lot from the mothers and the wives where they're narcissistic. Soon to be ex-husband says, I'm going to file for bankruptcy and I'm going to wipe you out. No, he's not. It cannot be done. Couldn't be done yesterday, can't be done today, can't be done tomorrow. There is no option to wipe out a domestic support obligation when it comes to bankruptcy. As a matter of fact, when they changed the law in 2005, they took it a step further. You cannot even wipe out attorney's fees that are related to a DSO. So if you go to court and your attorney is arguing an issue related to child support, let's say 1 hour, and then another hour devoted to something else, let's say who gets the car, that 1 hour cannot be discharged. So when they tell you, I'm going to file for bankruptcy, I'm going to wipe out everything, no, they're not. It cannot be done. Don't listen to them. You're just being a bully. Listen to me. I know what I'm talking about. They don't know what they're talking about. And they also don't have your best interest in mind. Remember that. They have their interest in mind. So they're never going to say something that is going to hurt their case. That's just the reality of family law. I did it for more than 2 decades, so trust me, I'm an expert on this. But now, what do we deal with DSOs when it comes to priority claims? Well, simple enough. A priority claim, it just if we're dealing with a Chapter 13 case, when again the law in 2005 said we're going to make this a priority, and it sounds like exactly what it is. It's above and beyond other types of debts. In this case, unsecured debt. So, like your credit card, if you're in a Chapter 13, I want to be clear, you're not wiping out this debt that's in the DSO. You're just using a Chapter 13 to catch up with this obligation. Then the reality is you're not going to be able to wipe this out with the bankruptcy, and on top of that, it gets paid on top of all the other debts. So when that narcissistic spouse says, "I'm going to file Chapter 13 and I'm wiping you out," the answer again is wrong. The answer is it's a priority claim. It gets paid before everyone else, or before American Express, Bank of America, Mastercard. Before they get paid, your priority claim gets paid, your DSO. So keep that in mind. There's already two strikes now against the narcissistic spouse. There's no third strike, but we'll play with two strikes, so that's two times that you're wrong. Again, don't listen to them. Now, this is the important part. Actually, we'll make this strike three. I don't know why judges continue cases when it comes to automatic stay. When the automatic stay, remember, it stops certain types of cases, foreclosure, credit card lawsuits, good way to stop a wage garnishment, etc. But I don't know why there could be a hearing scheduled for an issue of child support, and the obligor says, I filed for bankruptcy 3 days ago, and the judge says, I'm rescheduling today. Why? Why? It's clear. Not even, remember, I had over here attorney's fees. Not even attorney's fees can be wiped out in a DSO. And we know definitely child support and spousal support is not being wiped out. Why are we continue this hearing? I don't know. They weren't paying attention to judge school that day. Realistically, family court judges are not bankruptcy lawyers a lot of times. I remember one judge who practiced both, so she understood it. But a lot of times, these judges will continue the case. Now, how does this apply over here? Let me clear up the screen here for you a little bit. All right. Schedule I and Schedule J. What am I talking about? Well, Schedule I, real tiny there. Schedule I is nothing more than income when you're looking at the bankruptcy petition. In the bankruptcy petition, you're going to list your income, and you have to include all other financial contributions or support that you receive. So, for example, if you have a family member who's living in your house, I don't care if it's only for 1 month, if that's the month you're filing for bankruptcy, that $500 that they contribute to the household expenses has to be listed in Schedule I. But so does any alimony or child support you have. And the reason why is simple enough. If you have, let's say, 4,000 in income and you have 3950 in expenses, right? There's only $50 left over. You're thinking, great, I qualify for Chapter 7 bankruptcy. I have no disposable income. If you're getting $1,000 a month in support, these numbers change drastically, don't they? You just went from a Chapter 7 to a Chapter 13. So you have to make sure when you're doing your calculations to factor in any support you receive. Now, the other issue, oh, hold on. There's a little delay there. All right, so the other issue now we're talking about is how does it affect Schedule J? Schedule J, it's nothing more than your expenses. So on Schedule J, you list all the expenses. I have a mortgage, I have a car payment, I have insurance. You also have to list this obligation. Again, if you don't, your numbers are going to be all out of whack, and you're going to go from a Chapter 7 to a Chapter 13, or maybe the trustee just denies, you know, submits a formal request because it's a judge who denies it, and the judge signs an order saying your Chapter 7 hasn't been approved. It's because these numbers are out of whack. You have to make sure you list them all in Schedule I and Schedule J. Now, the important part, let's not do this twice, the expenses. If you're getting the income, if the spousal support or alimony and child support are getting withdrawn from your paycheck, don't turn around and then add it again in Schedule J. Again, your numbers are all out of whack and this is not going to work. So if it's getting deducted on Schedule I, you'll list that there as an expense. Schedule I will ask you, what's your gross income? What are you paying for? Oh, I'm paying for uniforms. I'm paying health insurance. All that gets deducted on Schedule I. And there'll be a section there for DSOs. Just put it in. That way the numbers all work out. Okay, so make sure you don't double up on your expenses. That's a good way to aggravate the bankruptcy trustee. Make sure you list it on Schedule J if it's not being deducted. And if you're receiving it, you have to put it in Schedule I. It's going to affect your bankruptcy case. Yes, it will, but you have to include it. There's no choice. The bankruptcy code that you're not going to read because it's extremely complex. The bankruptcy code is clear that that's included, and again, it should be. You'll see it on the petition. What you may not see, depending on the forms that you use, something that says, household contributions from a domestic partner, whatever. You can always handwrite that in. I live with my boyfriend or girlfriend, and they contribute $1,000 a month, and so that'll get listed there. Okay, but just keep in mind, most important part, we're dealing with alimony, child support, cannot be discharged. I don't care what they say. As a matter of fact, you're going to get paid before everyone else. The only group of creditors ahead of you are going to be secured debts like mortgages and car loans and those types of debts. Unsecured debts, they're at the back of the line when it comes to bankruptcy, Chapter 13 bankruptcy, and so what they really get in return is usually pennies on the dollars. Shouldn't affect your case. Should not. I like to say it won't, but I can't control what these judges do. But trust me, it should not. And then now you know how that affects Schedule I and J. Okay, got it? You just learned everything you need to learn about domestic support obligations. So thank you for that. Now, if you want to reach out to me, as always, well, there we go. Reach out to me on social media, or if you have any comments regarding this video, go ahead, post it in the comment section below, and I'll respond to you directly. And please subscribe to my channel. All right. Until next time, until the next video. Have a good rest of your day. Have a good rest of your week, and I hope to hear from you soon. Take care, everybody.